You may close.
I ask for your eye support on behalf of Astrid and the 75 to 100 other young students in California like her. Ask for your eye support.
Okay, at this time, we need a motion and a second.
I think there was a motion.
Now, Mr. Fong makes the motion. Mr. Sajian seconds.
Mr. Chair,
Yes. Okay.
I did second already, but I had, what are her commitments from that point on? Does she have any other commitments to the law enforcement? If I may ask that question, Mr. Chair. I know it's
You may ask. It's up to her whether to answer. I'm not.
I mean, not necessarily to her, but any of you ladies.
Mm-hmm.
I would love to answer, and I'd also like to give you my card so that we can continue, because this is my life. I'm a evangelist.
I just like to be educated and to
does everybody want to hear? So with the U visa, cooperation is she can't fail to cooperate between now and when she becomes a permanent resident in 4 years. Many times the case is already closed by the time someone gets non-immigrant status. She's already done all the cooperating that's going to be needed in her case. But there are others.
And the perpetrator's already been convicted and sentenced.
Right.
And he comes out in 1 year. What protection does she have?
You've got a criminal restraining order, and
10 years, and I got full legal and physical custody of my son.
Okay.
Yes, Astrid
I know
actually.
I'm getting off base here, but I appreciate allowing me to.
And I would love to give you my card. I would love to.
And that you can handle right after this.
Yes.
And the support of this
For now,
legislation will get her.
For now, we have a motion by Mr. Fong, a second by Mr. Asajian. Chair strongly supports this measure. Will the Secretary please call the roll?
Block.
Aye.
Block I. Olson. Asajian.
Aye.
Asajian I. Brownlee. Fong.
Aye.
Fong I. Galgiani. Lara. Miller. Aye. Miller I. Portantino. Portantino I.
5-0. Your bill is out. Congratulations.
Thank you very much, Mr. Chair and members. Appreciate it.
And good luck to you, young lady.
Okay, we've now come to the portion of our program where members present their bills. Mr. Fong. Mr. Fong will be presenting on item number 12, AB 2171.
Good afternoon, Mr. Chair and members. AB 2171 is similar to the bill AB 288 from last year. In fact, I had unanimous support from this committee on the bill last year. I'm bringing back this bill again because I feel when a student conducts a physically violent act in violation of the code of conduct and laws that govern behavior at a community college campus, the student has compromised his or her privilege to the openly accessible educational opportunities provided at community colleges. AB 2171 will provide a helpful tool for community college districts to protect students and personnel from other students who have been expelled for serious acts of violence. Violence has become a common form of expression in our society. A survey conducted by the California Student Services Organization confirms this point. From 2007 to 2009, 55 out of the 117 community college campuses reported 46 expulsions due to assaults, fighting, harassment, and other types of threatening behavior. Currently, if a California community college student is expelled from one campus for violent acts, they can re-enroll at another campus without disclosing their expulsion from the previous one. To compound the problem, community colleges are not required to share the pertinent information with other community college districts. AB 2171 will allow community colleges to share student expulsion information when an act of violence occurs. This bill will also give community college district the authority to conduct a hearing to determine if the expelled student still poses a threat to the student body and the personnel on campus. AB 2171 will ensure that there will be a process for re-enrollment after a student commits an act of violence on a community college campus. The intent of this bill is not to multiply penalties or bar access. Rather, it is to provide protection and safety to the student body and personnel on California community college campuses. AB 2171 will allow California community colleges to take action and place conditions on admitting a student who has previously expelled for serious acts of violence. Disclosure of acts of violence are standard in K-12, CSUs, and UCs. A student must seek permission to enroll at other community colleges similar to K-12, California State Universities and UCs. This bill will give California community colleges the same flexibility. This bill will thwart violent students and crime in California community college campuses, and we have an obligation to provide a healthy and safe learning environment for students, staff, support personnel on community college campuses. This committee unanimously supported a similar measure last year that Governor Brown vetoed. He indicated by requiring every community college to follow a uniform process for evaluating a student expulsion taken by another district adds unnecessary burdens and costs that the state will have to reimburse. We have amended the bill in a way that we believe addresses the mandate issue. Additionally, we have a Legislative Council oral opinion that the enrollment process does not create a mandate and are working on a written opinion that will be the same.
Been moved by Mr. Lara, seconded by Mr. Miller.
Okay. With me today, we have the support to testify is Mark McDonald, representing Kern, Peralta, Rio Hondo, San Diego, and San Jose Evergreen Community College districts.
Thank you, Mark McDonald, on behalf of the McCallum Group and on behalf of the Kern and Rio Hondo, San Diego, San Jose Evergreen, and Peralta Community College districts. I think the author identified the issues with the bill. I want to thank him for reintroducing the bill this year. We think that we have addressed the concern of the governor on the mandate issue, and I want to thank your staff for working with us on that. It was some of her suggestions that helped us with that amendment, and we appreciate that. I just feel like this is a bill that if we'd had an incident on a community college campus, we wouldn't be having to do this again. We're trying to be proactive and take steps to prevent these awful incidences, and we would appreciate your support. Thank you.
Thank you. Mr. McGee.
Thank you, Michael McGee, California Community College's Chancellor's Office. We continue to support this measure as we have done in the prior versions. We do believe that we need the bill in order to promulgate regulations or to provide any information sharing required of this bill to help prevent violent acts. Thank you.
Thank you.
I did want to note one thing. Bonnie Slauson from the Community College League is at another hearing, but wanted me to weigh in support of the league as well.
Okay, thank you. Any other witnesses in support? Any witnesses in opposition? Okay, we have a motion by Mr. Lara, a second by Mr. Miller. Chair supports this bill. Will Secretary please call the roll? Oh, wait, this was for a due pass to the Assembly Appropriations Committee. Secretary, please call the roll.
Block.
Block aye.
Block I. Olson. Asajian.
Aye.
Asajian I. Brownlee. Brownlee I. Fong.
Aye.
Fong I. Galgiani. Lara.
Aye.
Lara I. Miller.
Aye.
Miller I. Portantino.
Aye.
Portantino I.
7-0. Your bill is out, Mr. Fong.
Thank you.
Congratulations. Mr. Lara is next. We have 3 more bills. For those playing at home. Mr. Lara, this is item number 8, AB 2122.
Move the bill. Second.
Moved by Mr. Miller, seconded by Mr. Portantino.
Thank you, Mr. Chair and members. I will be brief. AB 2122 will provide greater protections for individuals who are eligible and have received accommodations for their disabilities throughout their academic careers. Many who face barriers when requesting accommodations on the law school admissions test known as the LSAT. An accommodation is when a student gets a type of modification from the standard test condition, for example, Braille, a large print booklet, extra time on their exam, or extra breaks between sections. Accommodations are necessary for students who, for example, have dyslexia, diabetes, vision impairments, ADHD, learning disabilities, or a physical condition. Specifically, AB 2122 will require the Law School Admissions Council, LSAC, to provide accommodations for individuals who received accommodations from post-secondary educational institutions, require LSAC to notify the applicant in a timely manner the decision to accommodate, prohibit the flagging of any score obtained with the accommodation, require LSAC to state the reasons for the denial of an accommodation in writing, Also require LSAC to establish a timely appeals process for the test taker who has been denied an accommodation. Lastly, require LSAC to clearly post information regarding refund policies for individuals whose requests for accommodations are denied. This bill and the need for greater protection in the law is evidenced by the insurmountable barriers individuals face when requesting accommodations on the LSAT. For example, in order for the LSAC to even consider certain requests, an applicant must provide a highly specific assessment and report. The private assessment may cost over $3,000 in addition to the $160 a student must pay to register for the exam and $155 per student must pay to sign up for the LSAC credentialing assembly service. In addition, under LSAC policies, when a student obtains extra time based on a cognitive or physical disability, his or her score is individually identified. A letter is sent to the law school which the student has applied to, notifying that an accommodation was granted and stating that the score should be interpreted with great sensitivity and flexibility. This letter also states the LSAC has no data to demonstrate the scores earned under the accommodated conditions have the same meaning as scores earned under standard conditions. If a student gets an extra time accommodation, the council sends a letter clearly disregarding a student's privacy. This practice is known as flagging. It creates a chilling effect that discourages individuals from requesting testing accommodations for their disabilities. People with disabilities represent nearly 20% of our U.S. population, but research shows that only 3.4% of individuals with disabilities are represented in the legal field, as shown by law students who requested accommodations in 2009 and 2010. Recently, the American Bar Association Commission on Disability Rights passed a resolution urging the administrator of the LSAT to improve the way it handles accommodation requests for test takers with disabilities. It has been brought to my attention that the opposition is questioning the need for AB 2122 and whether the problem really exists. Recently, a complaint was filed on behalf of several students in California against the LSAC Council on behalf of the Department of Fair Employment and Housing. This class action complaint highlights the need for greater protections in the law. AB 2122 is necessary to ensure that all eligible students receive accommodations and that LSAT measures what is intended to measure and not the student's disability. With me to testify is Paula Perlman, Executive Director of the Disability Rights Legal Center and visiting Associate Professor of Law at Loyola Law School, and Nora Devine, a student from the University of San Francisco School of Law. And here to answer any technical questions is Joanne Simon, an educational expert that is visiting us from New York this afternoon.
Thank you, Mr. Lara. Witnesses in support, a total of 6 minutes. Begin.
Good afternoon. Thank you for having me here today. My name is Nora Devine. I'm a law student at the University of San Francisco School of Law. As a student with a disability, I was and continue to be disadvantaged by the discriminatory practices and policies of the LSAC, in particular the LSAC's flagging policy. This discriminatory practice seriously disadvantages students with disabilities by effectively marking their scores as invalid. This serves as a form of unlawful retaliation against students who do exercise their right to receiving accommodations. This discriminatory practice also discourages many students from seeking the accommodations they require out of fear that this retaliation would be detrimental in their law school applications. I am one such student. I have low vision, a combination of eye conditions and a disorder called nystagmus that causes my eyes to continually scan from left to right involuntarily, make it difficult for me to focus my eyes for reading and other prolonged visual activities. My vision condition also causes severe and painful eye strain. I've been granted exam accommodations of large print and extended time throughout my education, as well as on the SAT. I did not, however, receive extended time on the LSAT. After learning of the LSAC's flagging policy, I decided not to request extended time. I worried that after reading the LSAC's flagging letter, law school admissions committees would seriously question the validity of my LSAT score and would likely discount my score as invalid or view it as inferior to scores achieved by others without accommodations. I also worried that the LSAC's flagging, which effectively notifies schools of an accommodation I received because of my disability, would highlight my disability in my law school admissions applications. Given the stigma attached to disability, I did not want to highlight my disability in my applications. And I did not want schools to receive a letter from the LSAC encouraging admissions committees to second-guess the validity of my scores. I decided not to request extended time on the LSAT. This decision not only negatively impacted my test scores, which in turn may have impacted my admissions applications, but also continues to negatively affect me to this day, because it may be held against me on my accommodations applications for the bar examination and the multi-state professional responsibility exam. I urge the committee to approve this bill. Thank you for your time.
Thank you. Next witness.
Good afternoon. My name is Paula Perlman, and I appear today at the request of the American Bar Association President William Bill Robinson III to present the ABA's position on accessibility in law school admissions testing. I currently serve as a member of the ABA's Commission on Disability Rights. In February, this past February, in New Orleans, the ABA House of Delegates unanimously passed our resolution 111, which I believe is in your materials, which urges that the LSAT to administer law school admissions tests in a way that complies with the Americans with Disabilities Act, that they take specific steps to ensure that applicants with disabilities have fair and equal access to admissions testing. We drafted this resolution in response to concerns reported to the ABA, concerns reported to the National Association of Law Students with Disabilities, of which Nora is the vice president, which is a national organization of over 300 members, which is working to eliminate stigma and bias towards law students as they attempt to enter the legal profession. And that the ABA felt so strongly about this that Bill Robinson himself put forth this resolution. So what do we want? These are high stakes tests. These are gatekeepers. You get a good score on the LSAT, you get into law school. The LSAT, this resolution and its accompanying report address the same points that are covered in this AB 2122. We want the LSAT to be administered in a way that will best ensure that the exam results reflect the student's ability. It doesn't reflect their disability. When we hear the term disabled, or we think the freeway, there's a car disabled on the freeway, let's disable the smoke alarm. It means something doesn't work. And actually what we're looking here for this testing is to show how something does work. What we're asking is that the student be tested based upon their ability. The test should reflect their abilities. And that's what the Department of Justice regulations require. Accommodations are supposed to level the playing fields. They're not an unfair advantage or a leg up. It's testing what the applicant knows under circumstances in which they can perform as other students do. Accommodations are not changing the standard. It doesn't mean you get to have a lower score.
1 minute total.
Okay. It means that the standard to which the applicant is held accountable is the same standard as every other student. Flagging that is discriminatory. It's an unlawful consideration of mitigation measures, and it ends up as being coercive because the student doesn't want to disclose, because their score will be flagged. So we're very concerned about the flagging, the ABA in general, the Commission on Disability Rights. We're committed to promoting a diverse legal profession and the rule of law in America, and ensuring that diversity is enhanced and biases eliminated in the legal profession. Thank you.
Okay, 15 seconds remaining. Any more testimony? Okay, any other witnesses in support, please come forward, state your name and organization you represent.
I'm Brandon Tartaglia with Disability Rights California in support of the bill. Thank you.
Thank you. Any other witnesses in support? Witnesses in opposition? Okay, witnesses in opposition, please come to the table. You have up to 6 minutes total. And will the witnesses in support please make way for the witnesses in opposition? Okay, you have 6 minutes.
Thank you. Good afternoon, Mr. Chair and members of the committee. I'm Joan Van Tol. I'm General Counsel to the Law School Admission Council. With me today is Jim Vaslick, Deputy General Counsel, and also from Pennsylvania with us is Dan Bernstein, the President of the Law School Admission Council. As you've heard, we administer the LSAT. The standardized test that one must take to gain admission to law school. It is a high-stakes test. There's just no debate about that. And that's what makes it such an important issue for us to appear today to discuss our position on the bill. We give the test 4 times a year in a standard condition, typically meaning set amount of time across all administrations in the world. We've been providing accommodations to disabled test takers for over 20 years, pursuant to the Americans with Disabilities Act. That's the comprehensive federal law that specifically governs organizations like LSAC. We receive approximately 2,000 requests a year for accommodations on the test. Of that 2,000 requests, we grant about, or slightly more than, 2/3. The accommodations range from additional test time to additional breaks, separate test rooms, braille, large print. We have a robust process that's been developed over 20 years that provides test takers with easy access to the forms to be used and the guidelines to be followed in requesting accommodations. These forms and guidelines are available at no charge on LSAC's website, and that's the preferred method of communication by most test takers. We provide an online tutorial to guide people through the request process. We do, in fact, notify test takers of our decisions on accommodations in writing, typically within 2 weeks of their request. We do give a detailed rationale for our decision. Test takers are permitted to request reconsideration of our decision if they're dissatisfied with it. In short, we already comply with many of the provisions of the bill that's before you today. So why do we oppose the bill? First, there's simply no factual basis for the concerns that have been noted in the background analysis. I'll be specific. There's no evidence that disabled test takers are systematically denied access to the LSAT and legal education. The numbers prove otherwise. There's no evidence that our procedures are inconsistent with industry standards. In fact, they were developed in collaboration with other testing organizations and with representatives from colleges and universities who provide student services for disabled students. There's a claim that that test takers from private schools are 4 times more likely to receive accommodations on the LSAT. There's no substantiation for that claim. There's no such study, and nor could any such study be conducted without access to our data. It doesn't exist. Second, grounds for opposing the bill. We are already subject to comprehensive regulation in this area under federal law as well as certain state laws. These laws provide protection and rights to disabled students who seek accommodations on the LSAT. The rights are there, and access to the courts and agencies is more than available. Third, additional regulation in the absence of a demonstrated need for it or evidence of the need for it will only add to confusion as to the intent of the law and most surely will spawn litigation. We're concerned primarily about the provision in this bill that would require LSAC to grant accommodations to someone on the LSAT simply because they had accommodations in college. That provision would violate the ADA's requirement of an individualized determination of the need for accommodation based on the current impact of the disability. In order to determine current impact, we need current information. Of course, history is relevant, but it cannot and should not be determinative. Imagine a first-year college student who had accommodations for a hand injury. She had a note taker, she had extra time, and maybe she even had a special desk. Under this bill, she would be entitled to those accommodations when she took the LSAT 3 years later, whether or not she was still injured. Would that be fair to other test takers? Would that make sense? We say no. Making accommodation decisions without regard to the facts is simply not good policy and is contrary to the ADA. We also have concerns about the bill's impact on LSAC's score reporting policy. My colleague Jim Vaslick will address those concerns.
You have 2 minutes.
Thank you, Mr. Chair and members. I did want to take my 2 minutes to further describe our policies and procedures for reporting scores on earned under non-standard time conditions, and also talk a little bit about the scientific basis that underlies those policies and procedures. LSAC has the benefit of getting law school performance data grades from law schools every year that allows us to validate the LSAT as a measure for admission purposes for law schools throughout the country and indeed international law schools as well. We also have undergraduate grade point averages so we can assess the correlation between those predictors of performance in law school and actual law school performance. The great thing about that huge database, which encompasses hundreds of thousands of law students over many years, is that it also allows us to assess the differential prediction between scores earned with standard time and scores earned with non-standard time. And what we consistently have found is that scores earned with non-standard time conditions simply do not perform in the same way. They do not mean the same thing as scores earned under standard time conditions. So our policy, based on that research, is if a package of accommodations includes additional time, test time, we do report that fact to law schools in ways that the member has described already. But our policy only extends as far as the research goes. So, for example, if the package of accommodations includes a private test room or something else that does not include additional test time, those scores are not reported as non-standard because our research does not support that. One last thing. The member cited the statistic about the proportion of lawyers who have disabilities, self-reported disabilities. I think the more relevant statistic is the proportion of disabled law students in the law student population. It actually is about 6.5% according to Department of Education statistics. And in fact, that percentage is higher than the percentage of disabled students in some disciplines that use admission tests where non-standard scores are not identified. So I think that, as Joan mentioned, there's no evidence that the score reporting policy has a detrimental effect. In fact, the evidence that's available suggests exactly the opposite.
Okay, thank you. Are there any other witnesses in opposition? Seeing none, we'll move to committee questions or comments. Mr. Sajan.
Thank you, Mr. Chair. As we speak, there is an existing law that allows them some time.
Oh, I'm going to have our expert here.
Let me ask a couple of questions. Maybe you'll cover it all together. And my understanding, if somebody who's disabled or have difficulties, however you want to describe that, is it required for them to have some kind of a written something of the nature from a physician or that qualifies them? And when we say extended time, what do we have in mind?
Thank you. Let me repeat. My name is Joanne Simon. I'm an attorney in New York, and I regularly represent students with disabilities with regard to matters about testing, standardized testing, and higher education. First of all, there is a federal law that is existing, which is the Americans with Disabilities Act. It would provide for reasonable accommodations, or in the case of standardized test organizations, for testing accommodations or modifications that would best ensure that the test tests what it is it's supposed to test, and not their disability. The fact that people have disabilities, the normal mechanics of these tests are barriers for students with disabilities. So while the comment was made that the score does not mean the same thing, unaccommodated scores for students with disabilities don't mean the same thing either. It's just that we don't know about that. The only indication we have of somebody's ability is an accommodated test score. In fact, very often people are not given the accommodations that they need or the accommodations that they request on a fairly routine basis. Yes, they are required to submit some sort of evidence. The Department of Justice regulations indicate that as long as it's a reasonable amount of evidence and is not burdensome, then an entity such as the LSAT would be permitted to do so. However, the department changed its regulations about 3 years ago, to indicate that they had been receiving requests or complaints from people with disabilities routinely because organizations such as the LSAT were requesting more and more and more documentation, including evidence that's not just within the last 3 years for which there's no scientific basis, but also requesting information from childhood, early childhood, IEPs, report cards, transcripts. All of that is very burdensome, and in fact most adults don't still have that information. And when that's the case, then that is often held against them, and they're either denied outright or there's no decision made on that, which effectively denies them accommodations that they're entitled to under the law. This bill provides for additional relief that would not necessarily be the same as the federal law, including the requirement that it post its information with regard to refunds. This is a policy, for example, I've never heard of anybody who's actually gotten a refund. It certainly is not well known. It certainly is not on their website, and it certainly is not communicated to students or when they are denied accommodations. The idea that someone who no longer needs accommodation because they no longer have a hand injury would somehow be getting these accommodations afterwards, I think, is something of a scare tactic. First of all, they rely entirely on differential predictive validity. The fact is that is the least effective validity to use. It's very, very problematic. And in fact, what they're doing by comparing people who have had accommodations and saying that they overpredict relative to people who have not had accommodations, they're comparing apples and oranges. And we end up, unfortunately, with a very confusing amount of fruit salad. So that is just very briefly some of the issues that would address your questions. And I'm happy to entertain any other questions you have.
If I may, Mr. Chair, I'm hoping that there are some privacy laws so that if somebody comes forward to say, for these reasons, I need the extended time, and then later on, if they want to get a job so that that won't work against them, is there such thing that if they go through the process, that gets in a file for that purpose only? Or how does it impact their future?
And I certainly, the LSAT can answer this question as well, and it is flagged for purposes of communicating the score. Mm-hmm. Again, it directly directs attention of the reviewer to that score and says it's not as good, when in fact we know actually that male students are overpredicted all the time, and we don't in fact flag male student scores. So we know that there are some differences that are just not addressed or not directed the reviewer's attention to. So that is a problem. Beyond that, it would only be a problem if somebody is asked to produce their LSAT score report, which would be flagged. And sometimes an employer might do that. That's not something that is necessarily the case. It's not just out there in the ozone, for example.
If I could respond directly to your inquiry.
It's up to the chair.
Yeah, go ahead.
LSAC does not release specific information regarding the test taker's disability unless the test taker asks us to do so and signs a written authorization and consent. The letter that accompanies a non-standard score makes no reference to a specific disability, and that letter goes to the law school and to the law school only. LSAC would not ever release that letter without the test taker's permission to a third party. It would be entirely up to the test taker to decide whether that letter would go anywhere else. So we do respect and honor the privacy of the medical documentation that's submitted.
And I'm respectful of that, but if I was to change my head around, and if I was to hire an attorney to represent me, and in the courtroom you need somebody that's on their toes, how would that impact my representation? Has that ever been a problem?
Not the LSAT score.
Not the score, but the performance in action.
Well, we hope that by the time they would represent you, they've gone through law school and they've passed the bar and been deemed to qualify.
So the disqualification then, or the difficulties, is only for taking the test, not necessarily how they perform.
That's
okay,
correct.
thank you.
That's
thank you.
Thank you, Mr. Sajjan. Mr. Portantino.
Yes, I have one question. It seems to me that I think there's one, I mean there may be more, but one sort of legitimate concern that jumped out at me, that if someone had a temporary disability versus, dyslexia, which you don't outgrow. I mean, if it was a broken arm for, and it was your writing hand and you got someone to accommodate, that's a legitimate concern, that it should be a current disability at the time of taking that. And that just seemed like a legitimate problem that could be solved easily in the bill. Did you want to comment on that?
I think that, in fact, your concern is well placed, but in fact doesn't come up that often. The vast majority of people who are requesting accommodations have permanent disabilities that are not going to go away, and by them asking for a doctor's note establishing that this person's hand problem, let's say, still exists, the LSAT would in fact be having information to indicate that it still existed. So I'm not sure that I understand why the bill would need to be amended, but
well, because it's the language that's before
right,
us.
And I will
not. I'm just asking the author.
Right. No, and I'll actually
clear up that issue.
I will work on making that clarification.
I think that's a reasonable.
Absolutely.
Clarification.
Absolutely. Thank you.
Any other questions or comments, Ms. Brownlee?
Yes, one quick question, and I think I've understood the testimony and the the conversation that's gone back and forth here, but I wanted to understand, based on the federal law that you mentioned, so are you saying it was the federal law or the courts that talked about the accommodations and modifications and whether one has that or not as being not burdensome or not?
Those are the federal regulations.
Those are the federal
and they're quite specific, and there's very extensive guidance to them as well.
Okay. I just wanted to understand, because it seems to me, and I must say, I am a mother of a dyslexic daughter who is now 26 years old and very successful in what she does, but I probably wouldn't be here today except having to have advocated for her since she was very little throughout her entire educational career, and that's what made me run for school board, and then from school board to the state assembly. So, I have personally been involved in these issues and been involved where she has been denied various accommodations and so forth that she needed in school. It just seems to me, by reading the analysis, and this is the only thing that I have read, that it does, to me, seem very clear that the Law School Admissions Council does have kind of a higher threshold by federal law burden than other testing institutions. Just by reading the analysis, that seems to be the case. To me, it does. And I want to be respectful, obviously, and having my own experience with this, being very respectful of the law and making sure that we're abiding by the law. So it just, the fact that we have to do all of this, it seems like additional testing that are assessments and assessments that may indeed cost money and so forth, just seems to me to be overburdensome. So I am sort of compelled to support this bill. Lots of times in this legislature, we end up creating bills and creating laws as a result of a lawsuit or some court ruling of some sort, and to me it seems as though we should take a good hard look at this process and determine whether it is overly burdensome or not, and we could prevent legal challenges down the road.
Yeah, I'd like to ask the LSAC people to respond to that. Do students who have a long, well-documented history of a permanent disability need to provide additional documentation and go through the testing again?
Their obligation is to provide documentation of the current impact, and that's the federal.
So that's a yes, then?
That's a yes. That's,
okay.
That's not our rule. That's the federal.
That is the federal threshold. You can certainly, okay. Mr. Lara? No. Okay. Any other questions or comments?
I think we need to
permanent.
That's not the federal threshold. There's nothing about recency or currency of the disability in the federal law or in the regulations. In fact, the Justice Department says, look, if you're somebody who's been getting accommodations for years and years, the testing company should just give the accommodations already. And in fact says the individualized assessment is not the individual assessment to be done by the testing company, but by the person who's actually evaluated the person. And it specifically says in the guidance that the company should give precedence to the recommendations of the person who's actually examined the person. That, in fact, in at least admittedly 1/3 of the cases, is not happening, and that's a problem.
Okay, we'll ask both parties to submit briefs as to this point. For right now, we will move on. We'll have Mr. Lara give a close.
Members, this is really just simply about, stopping this discriminatory behavior against our students with disabilities, and I just respectfully ask for your aye vote.
Thank you, Mr. Lara. We have a motion by Mr. Miller, a second by Mr. Portantino. The motion before us is due past the assembly floor. Will the secretary please call the roll?
Block.
Aye.
Block I. Olson. Aye. Olson I. Asajian. Asajian I. Brownlee.
Aye.
Brownlee I. Fong.
Aye.
Fong I. Galgiani. Lara.
Aye.
Lara I. Miller. Aye. Miller I. Portantino. Aye. Portantino I.
8-0. Your bill is out. Congratulations, Mr. Lara. The last two bills, item number 9 and item number 13, are chair bills. So I will ask my vice chair to conduct the hearing.
Very well. AB 2126 by our very distinguished chairman, Assemblymember Marty Black.
The chair's bills? Let's just
The
check.
chair's bills, yeah.
Thank you, Madam Chair. First bill, AB 2126, deals with the removal of a sunset for California State University authorization of its own regulations. Many years ago, back in 1997, the CSU was given authority to adopt many of its own regulations through its own in-house counsel. There are several requirements that they then report any regulations to the legislature and any challenges to their regulations to the legislature on a regular basis. There was a sunset when this bill first came to the legislature on the CSU's ability, and it's just a streamlining and efficiency standard. There was a sunset on CSU's ability to implement its own regulations. During the course of the last 20 or 14 years, there have not been any complaints about the current drafting process, and the CSU's authority has been extended by the legislature on two different occasions in 2001 and 2007. Now, the CSU is asking that they have the authority to continue without a sunset, that we basically remove the sunset. At this point, we have no official opposition to this. CSU, of course, is the sponsor. I have been in contact with stakeholders who do wish to continue the discussion, and I am happy to continue discussion as this bill continues with CFA and any other stakeholders. But at this point, I ask the committee pass on the bill.
Move the bill.
Second.
Witnesses in support?
Andrew Martinez, California State University. The author said everything I was going to say, so thank you very much.
Thank you. Any witnesses in opposition? Seeing none, would you like to close?
Ask for your aye vote.
Secretary, please call the roll.
Block.
Aye.
Block I. Olson.
Aye.
Olson I. Asajian.
Aye.
Asajian I. Brownlee.
Aye.
Brownlee I. Fong.
Aye.
Fong I. Galgiani. Lara. Lara I. Miller. Miller I. Portantino. Portantino I. 8-0.
And I apologize, that motion was due pass to the Assembly Appropriations Committee, and that bill is out 8-0.
Thank you very much.
So next we will have AB 2202.
Thank you. And just to remind members, I had neglected earlier to do the consent agenda, so we will do consent after this bill, so don't rush out, please. AB 2202. The LAO's office in 2010 reported on the master plan for higher education. The title was Master Plan at 50, Guaranteed Regional Access Needed for State Universities. We've seen reduction in funding. We've heard about that when previous bills were presented today, and the reduction in funding has reduced access for students. It's particularly a concern in certain geographic regions. AB 2202 directs the LAO's office to conduct a study that furthers their work in the master plan at 50 and looks at underserved areas and specifically directs the study to focus on strategies that leverage existing resources like regional partnerships and local guarantees. It requests that these findings or mandates that these findings be presented to the legislature by January 1 of 2014. With me today is Dr. Steve Boylard from the LAO's Managing Principal Analyst for Higher Education. I respectfully ask for your vote, Steve.
Thank you. Thank you, Madam Chair, members. Just a couple of real quick points to make that, as Chair Block pointed out, this is something that we've worked on kind of in a more focused area with regard to CSU and regional access. But the way I think the bill is framing some issues to go a little broader on that. It applies to all of post-secondary education. And when we look at access issues, I think, we're all very familiar that we've got the scissors problem recently where funding is in a downward direction, but we've had an increased expectation for higher education attainment. So the way we think about this bill is there's a lot of different kinds of facets to the idea of improving access that could have to do with student proximity to campus, the availability of enrollment funding, how that funding is spread throughout the system, allocated among the various campuses, admissions criteria, including impaction issues at the different campuses, alignment of the stages of transfer, facilities expansion, and the use of facilities. So there's a lot of different ways in which I think that you could have a study that more comprehensively looks at these facets of access and offers to the legislature, in the spirit, I think, of the Joint Committee's work on the master plan, a vision that addresses the state's need to improve post-secondary attainment. So we'd be happy, again, we don't take a position on bills, but we'd be happy to work with the legislature to expand on these recommendations.
Okay. Any formal witnesses in support? Any witnesses in opposition? Okay. Questions from committee? I have one.
Yes.
I know our CSUs and our UCs are obviously having tremendous challenges right now meeting the needs of their current students because of their persistent state budget cuts, and that's just an ever-present challenge, it seems. And so on the one hand, I question whether now is the time to explore avenues for expanding access. I think we all want to do that, but it's just a particular challenge when we're having a hard time meeting the existing students' needs. On the other hand, I love the comprehensive nature of the study that you're asking the LAO to do, particularly with the expansion of distance education. Those of us in particular who represent very rural areas, finding ways for the students up in the foothill counties or in Mono County to be able to access a public university is a real challenge, a real and present challenge. And so I think that there would be conclusions drawn out in the study that not only help the access issue, which is really important, but could also maybe provide some direction as to attainment to degree, how do we get the degrees sooner for the existing students? So maybe you could speak to a little bit of that in the LAO as well. As do you think that the study would lead to conclusions not only about access, but also how we get our existing students within the system closer to degree completion?
I'll speak to your point on timing, and it's very well taken. I mean, we're not going to be able to make the changes right now with our current budget constraints that will expand access. However, we are finally seeing the economy showing signs of turning around. This is a study that will be, if passed through the legislature, signed by the governor in October, become really a direction to the LAO in January, and we're asking for a report by 2014. So our hope is that by time the report comes to fruition, we will have resources to start to implement some of its recommendations rather than waiting until that time to urge a report. And as far as content?
I just make a couple of other real quick points that I think you make a good point that there's really limited funding, and it'd be difficult to come with a recommendation saying we need to expand the number of funded slots, for example. That's a pretty easy and obvious fix. I think most of the things that I was kind of sketching out, I think a lot of where the focus that you'd want some kind of help and direction on is how to expand the availability of higher education options at any given level of funding. So how can you make better use of allocating funding throughout the system? How can you make better use of distance education? How can you make better use of the facilities that exist, for example? So I think that really would be a very strong aspect of this report.
Thank you very much. And then finally, I know this is more of an appropriations question, but any cost estimates yet about what the study may cost, or do you think you'll absorb it in existing LAO operations?
This is a classic kind of report that if we were asked to do it, we'd make it fit within our normal resources. It would be a priority for us if the legislation were adopted.
Thank you. Any other questions from committee?
Quick question.
Miller. Almost said Senator Miller.
No, not yet. Congressman. For the LAO, I guess, in looking at the whole university system in higher ed, you'd have certain universities that have certain strategic goals, expansion opportunities, and as it all comes back to access, I know, for example, in my district, UC Riverside is on a quest to develop a medical center, teaching school, and allowing it, which would be an access issue. Would the LAO study under this bill address specifically on how UCR could achieve that goal? Where do you go with this, I guess?
Right.
I'm opposing the bill, but I'm thinking if there's some, opportunities that I might be able to get there.
But, obviously, depending on however the bill is framed, we'd direct our study to the specific needs expressed by the legislature. I guess the way I was thinking about the bill is it wouldn't be about campus specific. It'd be more generally a state strategy for expanding access. That said, I think the idea of expanding access in all the high priority areas the state has, being able to match needs for medical professionals, for example, would be one of the considerations of the legislation of our study.
Okay, thank you.
Assemblyman Ashajian.
Thank you, Madam Chair. This is pretty much a form of study that you're requesting. There are certain times when the economy is good, everybody's busy. My question to you is, how does it impact the load that you have in front of you as we speak? Times like this, are you less occupied? And when times are very good, you're more occupied? Or when times are good for us in the business world, we're much busier than it is today, so we will do stuff that otherwise we wouldn't have time to do. So tell me a little bit about your workload.
That's a fair question. And as you know, our office has it's been a pretty fixed budget, pretty fixed level of staff and resources. We don't get any additional funding for these kinds of studies. So it's really an opportunity cost question. It's not do we do more, do we do less? It's what are the priorities that we work on. So in this case, I think the group of us that really focus on higher education, the idea of access, affordability, and educational quality are all kind of general themes that we try and help the legislature with, depending on what your specific questions are. So again, I think if there's a question about focus, this would rise to take on more of our resources, and that would mean there'd be other potential studies that would get less attention.
Now, if this goes to top of your priority list, what goes to the bottom of the list? Are we going to put something otherwise would have been through the process and now neglected?
No. Well, I guess if you think about this as two levels, one is we have statutorily required tasks to perform. Either those are, we have some reports that are already required that you've asked us to do through statute. Mr. Portantino's AB 48 asks us to do a review of exemptions under the Post-Secondary Education Act that will be coming up in a year and a half or so. And we have another study of SB 1440 that we are statutorily required to do. We will do those, and we always complete those tasks that you've assigned to us. We then have more discretionary work. It's stuff that we decide that we want to put forward. Mr. Block spoke about our report on regional access at CSU. That was a self-generated report. So the opportunity cost would happen on our self-generated work. We would still continue to perform all of the statutory tasks that you've directed us to do.
If the end result from your homework, what would that mean? If you come up with something positive or to Mr. Block's liking, where do we go from there? Or what would this do? What does the end result do to us? Or where we go from there?
I think as so many of our other reports, we try and make recommendations to you on, we try and think about specific state strategies, legislative strategies that can be adopted, whether that is changes to statute, whether that is budgetary changes, whether that's direction you give to the universities in defining their mission. So I think first order is just very specific recommendations to you on changes. But more broadly, I think we try to influence the broader conversation. These are problems that I don't think any one group of members or one house has identified. I think these are issues that the segments themselves grapple with, the Board of Trustees of CSU, the Board of Governors of Community Colleges, UC Regents. We are in conversations with them as well, and I think we'd like to be able to help offer suggestions and engage in a dialogue with them as well. So I would see this as a broadening, a movement of the conversation about post-secondary
So your
access.
findings become a recommendation, and it's upon us.
Up to the legislature to make changes if you so desire. They're strictly recommendations.
And no additional cost. You're there
Correct.
to do what we're asked of you to do, and with all the guarantees that nothing falls off your priority list because
Correct.
this comes true.
That's
Thank
correct.
you.
Any other questions from the committee? Okay, and I think we had a motion. Did we have a motion? Okay, would you like to close?
Sure. This simply comes down to, is it good higher education policy for us to study now better access for students so that when the time comes that we can make changes, we have information on which to base legislation, on which to base discussions with the CSU, the UC, the community colleges, on which to base discussions with the governor's office. It's all about generating more good information for us to make decisions. So I urge your aye vote.
Thank you. So we have a motion and a second. The motion is due pass to the Appropriations Committee. Secretary, please call the roll.
Block.
Aye.
Block I. Olson.
Aye.
Olson I. Asajian. Asajian I. Brownlee. Brownlee I. Fong. Fong I. Galgiani. Galgiani I. Lara. Lara I. Miller. Miller I. Portantino. Portantino I. 9-0.
That bill is 9-0. Or, I'm sorry, the vote is 9-0, and that bill is out.
Thank you very much. Now we will move to the consent agenda, and then we will have some bills still open on call for members to add on. So for the consent.
Move consent. Second.
Moved by Mr. Portantino, seconded by Mr. Miller. Will the Secretary please call the roll?
Block.
Aye.
Block I. Olson.
Aye.
Olson I. Asajian. Asajian I. Brownlee. Brownlee I. Fong. Fong I. Galgiani. Galgiani I. Lara. Lara I. Miller. Miller I. Portantino. Portantino I. It's 9-0.
The consent agenda is 9-0, so the consent items all pass. At this point, I'll ask the Secretary to read the roll on the bills where not every member has voted, and members may add on. Will the Secretary please call the rolls on various bills?
AB 1561, Brownlee. Brownlee I. Fong. Fong I. That's 8-0.
8-0.
AB 1723, Brownlee. Brownlee I. Fong. Fong I. Miller. Miller I. That's 9-0. AB 1743, Brownlee. Brownlee I. Fong. Fong I. Galgiani. Galgiani I. Portantino. Portantino I. That's 9-0. AB 1826, Brownlee. Brownlee I. Fong. Fong I. That's 7-2. AB 1899, Olson. Olson I. Brownlee. Brownlee I. Galgiani. Galgiani I. Lara. Lara I. It's 9-0. AB 2122, Galgiani. Galgiani I. It's 9-0. AB 2126, Galgiani. Galgiani I. It's 9-0. AB 2133, Brownlee. Brownlee, I. Fong. Fong, I. Portantino. Portantino, I. That's 9-0. AB 2171, Olson.
Aye.
Olson, I. Galgiani. Galgiani, I. That's 9-0. AB 2250, Brownlee. Brownlee, I. Fong. Fong, I. Miller. Miller, I. That's 9-0. AB 2478, Brownlee. Brownlee, I. Fong. Fong, I. Miller. Miller, I. That's 9-0. That's it.
If there's no further business, this meeting of the Higher Education Committee is adjourned.